Ready? Okay. So, Sandra, can you hear me okay?
Yeah, it could be a little bit better, I think. It's a little bit.
Yeah, it's a
Maybe
problem
speak
with
louder.
trying to do it through the computer, but I don't think these work. Let me just try this. I think we had a problem doing this one time. Can you hear me now?
Yeah,
And is that better?
I think so, yeah.
All right, then that's what we'll do. Okay, so it's my pleasure to present this webinar today on behalf of PUA Arch Insurance, and I'm going to start by turning it over to Sandip Chandana to introduce the program. So Sandip, take it away.
Yeah, thank you. Thank you, Kent. So I'm Sandip Chandarana, Director of PUA. We are the MGA for Arch Insurance Company. And here at PUA/Arch, we are very much focused on risk management. We view it as a win-win. Risk management leads to better loss experience for our insureds, which leads to lower premiums for all of the architectural and engineering firms that are online today. And it leads to a better loss ratio for us. So that's a win-win. Professional liability insurance is really comes right off the bottom line. So whatever I know it's a big ticket item for most of the insureds out there. So whatever you save there. So, risk management, we view it as a culture, not just something to reduce the premium on. So, and one of the value adds that we offer under our program is Kent Holland and his services to dovetail with your risk management efforts. So, Kent is one of the best in the business. When people ask us what differentiates us from our competitors, I always say Kent Holland. He's written textbooks on the subject, and he knows risk management like the back of his palm. So, Ken, thank you for everything you do for us. And with that, I'm going to turn it over to you.
All right. Well, thank you so much, Sandip, for that very nice introduction. I appreciate that. Well, what we're going to do today is we're going to do a subset of contract clauses. And what we're going to focus on are kind of the key clauses. So when you send in a contract to your professional liability broker or to your risk manager, your attorney, or to your insurance carrier that might assign it to me, for example, these are going to be some of the key clauses that we're going to look at. And I'm really going to focus a lot on the indemnification clause. I'm going to show you litigated decisions that impact how courts interpret indemnity. And then we're going to focus on some actual changes to the clauses that we redline. And I'm going to give you an exact clause out of a contract, and we're going to actually redline that together and show you what we do. And then we're going to talk about limitation of liability and waiver of consequential damages. So those are going to be our three key areas today. And I don't have as many slides as I normally put into a program. So I might be able to talk a little bit slower, and I will ask you for comments and participation along the way. So I'm going to stop and ask you to please use the chat room. If you're having any trouble hearing me, please let me know. I've plugged in my headphones, and I hope that you're hearing me okay. But if not, please let us know, and I'll try to figure out something else. So here we go. Okay, here are the learning objectives. This is an AIA filed course. So if you're an AIA member and you would like to have us submit your AIA credit, please, at the end of the program, send us an email with your name and your AIA member number, and we'll take care of getting that filed. If instead you need a written certificate or you want the AIA plus a written certificate, let us know that, and we will send you a certificate of attendance. Okay, let's start with looking at who is an indemnified party, who's being indemnified. And one of the concerns that we have is that it seems like owner contracts, when they're drafting a contract, they're making the indemnified parties a broader and broader universe. And so instead of saying you're going to indemnify your client or the owner or a few select people, it says you're going to indemnify your client, who might be a contractor. Maybe your client is another designer. And then it often will say you have to indemnify the owner. And then sometimes it'll say you have to indemnify the indemnity's representatives and agents. Well, the issue of who is a representative is a real big concern. because different courts will look at the term representative and say, well, yeah, that might be a construction manager, maybe it's some architect. And you shouldn't be agreeing to indemnify somebody that you don't know who they are. And so I will sometimes have a project where it's an owner in a place like New York City, where they say, well, look, we're just a huge developer here, and we need you to indemnify our representative. And my response there would be, all right, but who is your representative? If it's a certain corporation or a certain individual, give us that name and we'll identify that representative by name, and that would be okay. But here's what happens if you just use the general term representative. In this particular case, a prime contractor had to indemnify the architect per the indemnity clause that required it to indemnify the owner's representative. Okay, and so the court said that the architect fell into the category of a representative of the owner. So that was a New York decision from 2019. The issue with that is you'll find, there's another court in New York that says, well, the term agent is somewhat ambiguous. And so the court did not interpret the word agent the same way, but other courts would say, well, even agent might include someone like a construction manager or an architect. So whenever we look at the indemnity clause, and you'll see when we redline it later on, we strike out those words, agents and representatives. Now, indemnification, this article on page 5 of the slides, designers should never agree to defend their clients against professional liability claims. There's no common law duty to provide that defense, so you are creating it by contract. And there's a contractual liability exclusion in your professional policy, and it says there's no coverage for liability that you incur strictly by that contract indemnity clause unless the court would have imposed that liability in the absence of that contract clause. So again, the court's not going to typically impose on you a duty to defend, but if you agree to that duty to defend in your contract, no coverage for it. Now, if you're in California doing work, and I know some of you are in California, and we review a lot of contracts in California, we will always insert, if it says you're going to indemnify and hold harmless, then we'll insert paren after that, but shall not defend, or shall not defend against professional liability claims, close paren. And the reason for that is that courts in California still interpret the state statute to say that if you agree to indemnify someone, then you are simultaneously agreeing that you are going to defend them as well. And so a recent court decision in California, that's what they stated, was that, in California, if you do not want to indemnify and defend somebody, then simply say you're not going to defend them, and the court will honor that. Now, if you can't delete the words defend altogether, then add to the end of the indemnity clause something like I have here on page 6, where it says the duty to defend shall not apply to professional liability claims. And what that means is, yes, you'll defend against general liability claims, and after all, your client's probably an additional insured under your GL policy anyway, so that's not the same concern to you that you have when you're providing the professional defense. So again, this is a case from 2019 in California called Syntax Homes, and this case specifically interpreted the old Crawford versus Weather Shield case and said, yeah, that decision still holds. And I've had California attorneys say, hey, Ken, you're in Washington, D.C., you're in Virginia, you don't understand California law. And I'm like, yeah, I feel very comfortable that California says that if you don't want to defend, you need to say so in your contract. And so, my response to a California attorney who argues, well, no, you don't really need that. I'm like, well, good. Then you agree that you don't really want us to defend you. So let's just clarify by specifically putting that in the contract. And then they typically agree. Now, when it comes to indemnity, it's very important to understand what it is that we're indemnifying for. Historically, indemnity clauses were to indemnify people for their when they caused a bodily injury or property damage. It was more of a general liability type of an indemnity clause. But that wording eventually got removed from contracts, and most project owners today just simply say, well, you're going to indemnify for all damages and losses and costs incurred by your contract due to, and they'll say, basically anything and everything. Well, that's way too broad. And so the issue there is, to the extent that you're going to have that type of wording where it doesn't restrict it to BIPD, you certainly need to limit it so you're not going to indemnify your client for your client's own damages or losses that they allege they sustained because of your services. If the client wants to make a claim against you for that kind of a loss, they need to make a claim in court. And then you can have an expert witness testify on your behalf and say, no, you met the standard of care, and your client cannot prevail against you. But if a client can simply grab money from you from your fee under the withholding clause and say, well, we feel confident that you owe us money under the indemnity clause, well, they never make a claim against you. They never have to go to court to prove anything. They just hold your money. Then you're in this sad situation of having to sue your client for fee. And when you do that, I think the statistic is about 85% of the time, there's going to be a counterclaim against you by that client saying that you did something negligent. And my own personal experience, every time I've represented a design firm that has put in a claim against a client, that's what's happened. There's been a counterclaim. So the issue then becomes the difference between a first-party claim and a third-party claim. So the point here on slide 8 is that courts in different states reach different conclusions when it comes to what is an indemnified party covered for. The first-party claim means they can recover from you if you're the indemnitor, design firm. They can recover from you their own losses, their own damages, even if there was no third-party claim against them. We want to limit it to third-party tort claims and damages from those claims. So that's what we always try to do, and you'll see why here as we go through these cases. So I'm going to show you several cases that really focus on this point. Here's a New York case called Wsa Group versus Dki Engineering, 2019 decision. Here the plaintiff was allowed to recover its own damages, even though there was no third-party claim against it. The court said, yes, it's a familiar principle that a cause of action for common law indemnity must be based on a defendant's breach of a third party, but this case didn't involve that kind of a common law indemnity. This, instead, the scope of the defendant's obligation is governed by the party's intent as revealed by the plain language of the contract. So the court saying, well, don't tell us what that historically common law meant you only indemnify for third parties. We know that by contract, you can agree to anything we want, and we are going to honor your contract. The next decision I have here is one called Hensel Phelps. This is in Washington, D.C., down in my neighborhood. And in this case, Washington, D.C. says, well, indemnity is only for third-party claims. And so here, a contractor had a guaranteed maximum contract. It subcontracted the engineering work to a design firm as its sub. And then the contractor made an indemnity claim against that AE for the extra cost that it says it incurred in order to comply with various code requirements due to the AE's design errors. Well, the court dismissed that claim and said indemnity is only for damages from third-party claims against the indemnity. So that was a great decision in Washington, D.C. You can see it's exactly the opposite of what would have happened in New York. Now, Maryland, that's right next to Virginia and D.C. We're all in the same neighborhood here, and I've litigated in all three. And in Maryland, the court says, yeah, if you want the indemnity obligation, if it's not clearly stated to the contrary, it's going to include first-party indemnity and attorney's fees. So here, there's an indemnity clause. It obligated the contractor to defend and indemnify a property owner from all claims, demands, debts, actions, causes of action. And notice how that's written. It's all jumbled up. This is one of the things you're going to see when we talk about how we redline a clause. I don't like to see it where it says we're going to defend and indemnify, and it says claims, demands, and then it says debts, actions, then it says causes of action, suits, obligations, losses. So they've mixed up these terms. What we'd like to do is say we're going to only indemnify against third-party tort claims, causes of action, demands. And then I'll put paren here and after claims, close it, and then say and the damages, losses, etc., arising from those claims. So this way we don't end up indemnifying our client for anything other than losses coming from those third-party claims. So in this case, in Maryland, the court said that it applied to first-party claims for the property owner's own losses and damages. And that included the attorney's fees. New Hampshire. Now, this is a really interesting decision, and this is a really important one. This is a little bit older, 2016, but I still like to put this in all my slides because this is one of the more important cases I've seen on the point that we're talking about. Here, an AE had to defend its client, a town, against a contractor suit. And this was just a run-of-the-mill contractor change order claim. So here the contractors went to the owner and said, I need a change order because of these inconsistencies, these ambiguities in the plans and specs, and I'm having to do it differently at more cost. So the owner gives it to the AE to analyze it. The AE says, no, there's nothing ambiguous about this. This contractor is simply making up a claim. He's not entitled to it. So the owner listens to the AE. They deny the change order, get to the end of the project, and that contractor makes an affirmative lawsuit against that owner saying, well, you didn't pay me the change order, but now I'm making a lawsuit against you to recover those. Typically, what we want to happen in that situation, we want the owner to come back to his AE and say, hey, AE, I want you to help me with this suit. I want you to help me, get an expert witness. I want you to sit with me. I want you to help me testify, whatever. Help me explain and defend against this suit. But we don't actually come in and defend the suit. We just simply assist. Well, in this case, the owner didn't do that at all. The owner just simply tendered the claim to the AE and said, hey, under your indemnity clause, you're required to defend and indemnify me for these losses. Well, that's a terrible result. So now the parties are all split up. So here the court looked at it and said, sure enough, this indemnity agreement was so broad that it obligated the AE, which was AECOM, to actually defend the town against this contractor claim. And one of the things I want to show you here is what happens when you use the words arising out of. This court explained that those words are so broad, when you put those in an indemnity clause where you say we're going to indemnify for all damages arising out of, there's no proximate cause required to prove your damages. The court says that the phrase arising out of has been construed as very broad, general, comprehensive term, meaning it originates from or grows out of or flows from. The court said arising out of does not mean that any losses or claims must have been caused by the engineer's negligence or breach, nor does it require an action for negligence or breach. So the court's saying, once you say you're going to indemnify for things arising out of, the way I look at it is you may as well have been sitting in your bathtub at night thinking about the project. You're going to be liable. So I always strike out those words arising out of, arising from, and I insert to the extent caused by. Well, in this case, AECOM said, they argued to the court, well, Judge, we did that. We used to the extent caused by. And the court said, no, not really, you didn't. The language was, oops, I don't have a language. Okay. What, I guess in my brief presentation today, I didn't put that clause in, but what AECOM did was they said to the extent arising out of. So they put the two things together. So they said to the extent arising out of. The court said, well, as soon as you use the words arising out of, even though you have the extent caused by right in front of it, still meaningless. Those words arising out of just make you totally liable. So always get rid of those. That's my recommendation. Just whenever you see those terms, get rid of those. Revise them to say you're only going to indemnify for those claims to the extent caused by your negligence. Let's look at Florida. Here, the indemnity was for third-party claims only. The indemnity clause was said to apply only to damages for third parties and not to first parties. To make the indemnity apply to first-party claims and damages, the court says the contract in Florida has to expressly state that intent. And here the contract was ambiguous. So the court says, no, just like Washington, D.C., we're going to interpret that to mean it's going to only apply to third-party claims, not first-party claims. Georgia, right next to Florida, went exactly the opposite way. And this is a case where the Walmart, and if you've seen Walmart parking lots, you know they allow a lot of tractor trailers to just come to park there. And they sit there all night. It's just one of the nice things that Walmart does, truckers and RVers. The problem is you'll see that a lot of these parking lots get like dimples or little potholes where these trucks park. And that's what happened in this parking lot. Well, Walmart sued its contractor and its AE that designed and constructed the parking lot saying, well, this parking lot shouldn't have sunk in like that, and these parties are liable. Well, the engineer argued that, well, no, it's not liable. It had an engineer defend it with showing that it met the standard of care, etc. But what happened is, looks like I didn't explain what happened, so let me explain to you. Here, the Walmart didn't make an affirmative claim against the architect and its contractor in court. They didn't go in with an expert witness to prove that they were negligent. What they did was they just grabbed money under the fees and said, you know what, under the indemnity clause, you, Mr. Engineer, are obligated to indemnify me and defend me against any claims. And so therefore, you are obligated to cover me, and it wasn't just claims, it was also damages. Therefore, you are required to cover me for all my damages to repair this parking lot. And the court looked at the clause and said, yeah, that's true. There was no third party claim against Walmart, but Walmart was able, under the indemnity clause, to recover from the AE. Now, the irony here was at the trial, the engineer proved that the contractor through bad construction was really responsible for almost all the damage. So the AE only ended up liable for $40,000 out of like a $500,000 total. Contractor had to pay several hundred thousand. And then the AE ended up having to pay a few $100,000 in attorney's fees that Walmart incurred in the litigation, because the court said, well, the indemnity clause includes and attorney's fees. So therefore, this is like a prevailing party clause. And since Walmart won $40,000 from the engineer, they got to pick up $300,000 in legal fees. To me, that's a terrible result. And so for that reason, that's another good reason not to allow your indemnity clause to cover first party claims. The other thing we do is if you see a prevailing party attorney's fees clause in your contract, either strike it because there's no insurance if you agree to pay for your opponent's attorney's fees. If they won't strike it, then I recommend that you define the term. So we've written a definition, and I don't have it in my clauses today, but the defined term says to prevail, you've got to win 67% of your claim. And that means if you get this crazy contractor that comes in with a $5 million claim, but they only win 300,000, well, then they lost. And then you're deemed the prevailing party because you certainly, prevailed. You got more than 67% success, and therefore you get your attorney's fees. But the other thing I add to that clause is I say, in no event can the attorney's fees be more than the compensatory damages that were awarded to the winning party. So in other words, if that contractor or owner sues you for $10 million, but they only win 300,000, then the most they could ever get in attorney's fees would be the 300,000. That's really important. Okay, I'm going to take a break there before going on to this next set of clauses, and I want to ask you if you have any chat room questions, please put them here. And I need to find my assistant because I don't know where my chat room questions are. So while she is going to bring me my chat room questions, please put them in there. There must be some questions. I'd also like to hear from you. Tell me if you can hear me well and things like that. Right? Okay, I'm seeing a couple comments saying you're having trouble hearing me. I hope that's, I hope you're hearing me okay. I don't think I can talk any louder in this microphone. Can somebody confirm, are you hearing me okay? Do I need to do something different? Do I try to use my computer microphone instead of my headset microphone? And any comments or questions on anything we've covered so far? Okay, good. I just got a comment here saying that you're hearing me just fine. Thank you. Okay, well then let's continue. Next thing I want to talk about is what happens with an indemnity clause that might be broader than the state's anti-indemnity statute allows. In this particular case from 2017, Johnson versus Hamp Construction, the indemnity clause was so broad that it violated the state's anti-indemnity statute that prohibits recovery when the damages that were sustained by these third parties are caused by the public owner's own negligence. So in this case, the clause would have allowed technically this owner to recover damages for indemnifying a third party, even if those damages were caused by the owner. Well, that went beyond the state's anti-indemnity clause. And the trial court found that because it was so broad, it was void and unenforceable. But that decision got reversed by the appellate court that found, well, wait a minute, that's not the particular type of damage being sustained here. This wasn't damage caused by the owner. It was caused by the indemnitor, the architect or the contractor who was providing the indemnity. So the court said in that case, even though the wording of the clause was so broad that it might have been void, because it has that wording to the fullest extent permitted by law, that entitles the court to revise the clause for you. The court is allowed to redline it just like you and I would, to make it as broad as the parties intended without violating the law. So here the court just said, okay, we're going to keep the clause. We're just going to redline that part out. And that doesn't take away the indemnity because this wasn't caused by the indemnity anyway. It was caused by the indemnitor. Therefore, it is sustained. Okay. Now, the next point I've got here is be sure that when the indemnity clause has the word negligence in there, saying you're going to indemnify for your negligent acts, errors, and omissions, make sure you understand where that is located in the wording. In this particular clause, it says the designer is going to indemnify the client for claims, damages, expenses arising out of acts, omissions, errors, or negligence of the design firm. Now, notice negligence is not where it belongs in that sentence. It's at the end. And that was very cleverly written by a project owner. And I've seen it written this way in multiple contracts where the owner says, what you're really indemnifying for is every act and omission you have, even if it wasn't a negligent one. And, we're not expected to be perfect. The courts around the entire country say that design firms are held to a standard of care. You're supposed to do as generally expected of other design firms in your same time, place, location, everything. So you're not supposed to have no errors and omissions, just you can't have negligent ones. Well, here you would be agreeing to indemnify your client for every act, omission, error. So you need to fix it by putting negligent in front of acts. Okay. If you happen to leave the clause that way and say you're going to indemnify your client for every act, error, and omission, what you've really done is you've changed the standard of care. So here you came to us or your broker, and your broker redlined your contract and fixed your standard of care that says, no, you're not going to comply with the highest standard of care. You're not going to give any warranties. You're going to only do the generally accepted standard of care. Perfect. But then by the indemnity clause, you're like, well, forget that standard of care clause we told you about. We're going to agree to indemnify you for any damage that you arise from any mistake we make. So for example, compliance with law, and I've had 3 cases like this where my engineering client was required to indemnify their owner for damages sustained because a fire marshal came in and came up with some squirrely interpretation of a fire code that 9 out of 10 engineers never would have come up with. And they go, oh no, you've got to redesign this whole building because you've got to put these big fans on top of this commercial building that we didn't put there. That cost $1 million. And the indemnity clause required us, we couldn't defend ourselves and say we met the standard of care. It just said we had to indemnify for all those costs. No insurance for that. That's not an insurable claim. So be aware, you don't want to change your standard of care by a strict indemnity clause. Now, a drafting tip. So what we do is we make clear that the indemnity is only for third-party claims. And so we'll typically, when it's all mixed together, like I showed you before, with the terms like claim and damages and cause of action and then losses, they don't state claim, action, proceedings. They just sort of mix and mingle all these together. We simply move all those words like claim up to the beginning. We say, we're going to indemnify you against a third party. I like to use the word tort, claim, action, proceeding, cause of action, paren, hereinafter, claim, close paren, and then we'll say the losses, judgments, etc., arising out of those claims to the extent caused by your negligence. So I hope that makes sense, and you'll see that more when we practice in redlining the clauses coming up at the end here. Okay, and here we are. Okay, so now we're going to redline a clause that I found in a contract recently. Here's the clause. and we're not going to read this whole clause, but here's what it looks like. It's a very long clause. That's the totality of it. And you'll have these slides. So these slides are, I think, downloadable from the program today. And if you can't download them, just send me a note and we will gladly send you a set for your file. I always, if you've heard me speak before, I'm sure that as a speaker, I put far more content in my slides than any other speaker because I'm hoping you'll keep these forever and use them as a resource. They're not just bullet points. These are actual things that I hope you'll be able to find useful. Okay, so let's take this clause, and you'll see the very first thing was it said, as it should, to the full extent permitted by law. That's good. And then it says the consultant covenants and agrees and shall at all times defend, indemnify, protect, and save harmless the owner, its members, directors, and employees, agents, and representatives, collectively indemnities. Okay. So we've talked about all the issues that we see in that clause we've been talking about so far today. And you'll notice it says we're going to defend. All right, we can agree to defend them against their general liability, their auto accidents or whatever. That's fine. We won't take away all defense, but we need to either at the end of the clause say the duty to defend doesn't apply to professional liability claims, or as I've done here, I just find it easier just write in the clause to say except against professional liability claims. And then the other thing I struck here was protect. This seems like an ill-defined term. You say, well, how are you going to protect me? To me, that means you're going to defend me. I think protect and defend sound too synonymous because obviously it's not indemnify and it's not save harmless. Why do you have the word in the clause? So I strike it. Strike out that word protect. And then you see I also struck out agents and representatives in this article. So that was all the very first sentence of the article right there with all those changes. And then we move on to the next portion. And here, again, this is a great example where they had all these words mixed up. They had claims and then losses and then demands. And I've changed it and I put it all at the top. I say, what are we going to indemnify them against? It's going to be third-party tort suits, claims, other actions and demands, quote, claims. Then the losses, damages, detriments, charges, etc., that are suffered on account of such claims. And that way, it's not what that does. That wording is designed to prevent you from having to indemnify that indemnity against their first-party losses. It means you're only indemnifying them from losses arising out of third-party claims. Why do I put the word tort in there? Is because in that AECOM suit against that New Hampshire town, if they had said they were going to indemnify their client against third-party claims, well, possibly the contractor claim was a third party as to them. Maybe that contractor claim might have been indemnified. I don't know. It's really a contractor breach of contract claim against that owner. Well, it's a claim. We're like, well, wait. We want it to be a tort claim, not a breach of contract claim. So that's why I put the word tort. I put that in there. A lot of owners reject that. A lot of indemnities say, no, we're not going to accept that word tort. And then at least we have something to negotiate with and say, all right, we'll give you away the word tort. Well, we've got to keep it third-party claim. The owner says, okay, fine. So it's just a negotiating tool, at least. And someone I see on the chat room says, not sure how to download the slides. And I will ask my assistant how to download those slides. And again, if you can't download them, just let us know and we will send them to you. Here's my assistant. Is there a way to download them? Okay, she says she will send them out. Not sure how you download them on this program. So if you want them, let us know. We will get them to you. Okay, now what we're indemnifying for, again, in this part of the clause on part 3, notice that I've revised this and we're saying we're going to indemnify against such claims to the extent caused by. So this is where we remove those words arising out of and we say to the extent caused by. And then we've added willful misconduct or negligent performance. Now, I realize willful misconduct, you have no insurance for that. I used to have one broker in New York. Every time I make that change, you go, well, what about the fact it's not insured? You know, I'm like, yeah, you know that. You're the broker. Just tell your insured. It's not insured. I'm doing this for the insurance company. I'm not going to always tell you what's insured and what's not. But I think that an owner who had this very broad indemnity clause that expected you to indemnify them for every act, error, and omission, if you try to limit your indemnity only to negligence and not for your willful misconduct, I think that owner's got a pretty good argument against you. Is wait a minute, you mean you can intentionally do a willful misconduct? You don't have to indemnify me for me? That's ridiculous. And I tend to agree with that. So I think that even though it's not insured or insurable, I don't see why you shouldn't be indemnifying them for that. And certainly when I'm representing an owner, I always require that of the contractor or the AE. So then we get to the end. Now notice this last part on this clause said that in addition to all those things that you're indemnifying for, this consultant is going to also indemnify for any failure of the work to comply with any applicable governmental laws, ordinances, rules, and regulations. And that's what I was talking to you about before. That's just deadly. Here you're affirmatively saying that you're going to indemnify against any failure to comply with a code. Code compliance is so ambiguous. I mean, you could get a code and have 5 engineers interpret that code differently. Then you end up with a fire marshal or somebody from your government type comes in and goes, "Oh no, this is what the code meant." No, nobody would think the code meant that. The problem is that your client has no control over that, and you have no control. So once the fire marshal comes in and says to your client, "You know what? You've got to do all these changes." The client doesn't want those changes, but you've agreed to indemnify and pay your client for all those costs. So you need to change that. Okay. And then this last part, what I did here, I wanted to use this clause to sort of show something that I do, and this may not have been the best way to do it, but here what they said was you're going to indemnify for negligence or willful misconduct, whether such loss or damage be suffered or sustained by the indemnities directly or by other persons who may seek to hold the indemnities liable therefore. So I think what that's trying to say by directly is their first party damages or from third parties, those who try to make a claim against them. I think that's what that meant. I just struck that because I've already covered that elsewhere by saying it's only going to be for their third party claims. But what I've said here is even if it's caused in part by the acts, errors, or omissions of the indemnity. And the reason we can do that is that we have already said elsewhere that we're only covering them to the extent it was caused by us. So the fact that we say we're going to cover them even if part of the damages were caused by them, it's not increasing what we've got to do. It's simply saying, yeah, if to the extent it was caused by our negligence, if it was 50% our negligence, we're covering 50% of the damages. If the other 50% was caused by you, we're not covering those. Okay, but even though you caused those 50% damages, that doesn't mean we're not going to cover you. And sometimes you'll see the words caused in whole or in part. We don't want that wording because courts will look at that and say, if you've agreed to indemnify your client for damages caused in whole or in part by you, that might mean you caused part of the damages, but you're going to indemnify them for the whole of what they incur. Not insurable. We strike that word, we say we're going to indemnify them to the extent caused by us. We can add this wording, even if it's caused in part by the indemnity. Okay, now what I have here is a standard form indemnity clause that my firm wrote. And if you don't know, so construction risk, we review a lot of contracts every year. I mean, if there's a firm that reviews more design contracts than us in a year, I'd be surprised. But I'm sure we review well over a couple thousand a year. Yeah, Tim Maines is sitting here with me, one of my main guys here, 3,000 a year. I don't know, it's thousands and thousands. I mean, we enjoy doing this. We're quick at it, and we get to see a lot of different contracts. And so what we've done is we have a template on our website at constructionrisk.com. And if you go to the top of that www.constructionrisk.com, somewhere at the top in the menus it says design contracts, and it says template of reasonable design contract clauses. And if you use that template, it's a little bit old now, but those are the template that we as a group, we have 5 attorneys in our group here, and that's what we all use is when we're reviewing contracts, so we're kind of on the same page with each other. So if you look at this clause, I think you'll find that on that template. And what we say is you're going to indemnify and hold harmless a client, and then it goes on. It just has, you're going to indemnify them from, damage and cost that they incur as a result of a third-party tort claim to the extent caused by your willful misconduct or your negligence. Okay. So, and then we say subject to limitations of liability contained in this agreement. I like that. A lot of project owners are going to strike that, but if you could have that in your standard form contract, that's really valuable. So if you have, as a design firm, a standard form contract where you give an indemnity clause, you shouldn't be offering indemnity broader than what I have here. And I feel like you should try to limit it. Say, if you have an LOL clause, then that applies. And, you know, I've litigated cases where we've had a $25,000 limitation liability clause, and the courts say, yeah, you're in the state of Maryland, that's perfectly enforceable. That $8 million suit goes away. All you can lose is $25,000, even if you're negligent. Well, if that client were in that same case trying to make an indemnity claim against me for $1 million they lost to some third party, and I have this limitation applies to the indemnity clause, then that's beautiful. They still can't get more than $25,000. Okay, now we're talking about limitation of liability. We still have about 18 minutes left here. So what we're going to talk about now is limitation of liability clauses. This is the other clause that we'd like to really focus on because this is so valuable. There are cases all over the country where design firms have been sued for millions of dollars, and yet they had a limitation liability clause that limited their liability to some certain dollar amount, or maybe their insurance proceeds available up to a certain amount, and courts have enforced those. Those clauses generally are more enforceable than an indemnity clause. They're very powerful clauses. I don't like to see them mixed and merged with an indemnity clause or with a waiver of consequential damages clause. I think it needs to be separate. And again, it ought to start off probably with, to the extent permitted by law or whatever, that type of wording. But here are some drafting tips. Make it a sum certain, make it your fee or some dollar amount, whichever is greater. And so, you know, we have sometimes a design firm that's only doing a $3,500 contract or maybe a $10,000 contract. And yet it might be on something where the potential damage from that contract could be astounding. And so to try to limit your liability only to your contract, the court might look at that and say, no, it's too nominal. There's not enough skin in the game. I'm not going to enforce that LOL clause. So what we like to do is say your fee or a dollar amount, whichever is greater. So if you have a $3,500 fee contract, then you may want to offer maybe $50,000 LOL if that's a greater amount. Or you could tie it to your available insurance, but if you do that, then you want to state that it's going to be up to the amount of coverage specified by this agreement. So we see limitation liability clauses where the design firm agrees that the limit of liability is going to be their insurance coverage required by the contract. Wait a minute. That might be okay, but on the other hand, sometimes I see it just say all insurance coverage maintained by the design firm. Well, you might be maintaining a $10 million AE policy. The contract only required $1 million. Well, you've now agreed to give them up all that $10 million coverage that you weren't even required to hold, and your client didn't even know you had. So we changed that to say it's going to be the available proceeds of insurance up to the amounts required by your agreement. That way, you're doing two things. You're saying available proceeds, so if the insurance has been eroded and exhausted on other claims somewhere around the country, and it's no longer available, then you don't have liability. If you do have liability and you do have insurance available, it's only up to the amounts that the contract specified, not your whole umbrella program or your excess program. And then when you're writing the limitation liability clause, some courts have said that you need to say every kind of cause of action that it can apply to. It needs to apply to your negligence, your breach of contract, your warranties, strict liability, everything you can think of. Because if you don't, the court will look at it and say, well, it says here it applies to negligence, but they're not suing you for negligence, they're suing you for breach of contract. And that wasn't limited in liability. There was a court in Florida in a case called DeWitt, a little bit old now, it's probably 10 years old. The court there looked at the LOL clause and said, that clause only says that it limits the liability of the corporate entity, the engineering firm. And here, the owner of the project sued the engineering firm plus an individual engineer. And the court said, well, we're going to enforce the LOL against the engineering firm. You can only get 50 grand from the engineering firm, but you can go ahead with that multi-million-dollar claim against the individual. Wow, what a terrible result that is. So now what we do is we make sure that our LOL clause not only limits the liability for the company, but it limits the liability of its officers, principals, directors, employees, etc. So now here's our example. And I'm not going to read all this to you. I'm just going to leave it there for your reference. But basically, you'll see it covers everything I said. It starts off with to the fullest extent permitted by law. It applies to not only the design firm, but its officers, directors, etc. Here we say it's going to be the fee or 50,000, whichever is greater. And I still see some firms will say their fee for 25,000, whichever is smaller. I say no way. I never want to see that clause. I always change that. And then finally, we have in this clause, it says the client may negotiate a higher limitation of liability for a reasonable additional fee, which is necessary to compensate for the greater risk assumed by the design firm. That's really a clever clause. And again, in your standard form contract, you may want to just put that right in there. And Tim and I have had that in a contract where we were in court and the plaintiff's attorney was arguing that it was unfair, it was unreasonable that we were trying to get out of this, I don't know, multi-million-dollar suit for $25,000. And the judge was wonderful. The judge basically said to the attorney, well, sir, I mean, you signed this contract and you agreed to this. And it says here you could have negotiated a higher LOL. Did you ask for that? I said, no. And in discovery, they asked us for every example where we'd ever done it. And we went back through, the company had all their records really organized. And we came up with like maybe 10 where people had asked over the years to be have a higher amount. And each one of those, we increased it. So the judge looked at it and said, well, sir, you could have done it and you didn't. So you're just asking this company to be your insurance company. That's your loss. And or it affirmed our 25,000 LOL. It was wonderful. So this clause works. I can tell you this clause works. At least it works in the states where I practice. And let me just say, as far as using any clause that we are showing you today, before you put it in your contract, you need to talk to your own attorney in your state to make sure it's going to work for you. If you get their advice, we're not your attorneys. We're just giving you general risk management advice here. All right. Now, the other clause that we like to use is the waiver of consequential damages clause. And this is a clause that you'll find in your standard AIA document. And it says the owner and the architect waive consequential damages for claims, disputes, etc., and is applicable without limitation to all consequential damages due to either party's termination of this agreement. Okay, that's the standard AIA wording. And I see wording like that in a lot of contracts. I don't think that's clear enough. I mean, it's better than nothing. But the word consequential, again, is an ambiguous term. And so different courts can look at that and go, I don't know whether that's a consequential or a direct damage. I mean, the fact that the stadium couldn't open and they all still had money, that's a direct damage that resulted from your delay. Why is that not a direct damage? I'm like, well, why don't we simply define some of the things that are considered consequential? So here we say, in our clause, we say that the waiver is consequential special damages, including but not limited to loss of use, profits, revenue, business opportunity, or production. We list out examples of the types of consequential damages that are being waived. And the way I look at this mutual waiver, this is primarily for the benefit of you, the design firm, or a contractor, if we have contractors on the phone today. This doesn't do much good for a project owner. So this morning I was reviewing a contract for a big project owner, and they're hiring a design firm right now. And I struck out the waiver of consequential damages clause. I'm like, from an owner's perspective, I don't see how this is helping you. This is helping the designer. And we strike it. And the owner's like, fine. It's always, I'm like, yeah, you shouldn't have that. It doesn't do you any good. So that's how we handle that. Okay, now we are at the end. I've got 10 minutes for questions, comments. I'll talk about anything on any of these issues that you would like to talk about. And let me see, I see a few questions here. How do you determine a reasonable additional fee for the higher liability limit? That's strictly something you can negotiate. I mean, if you are going to increase your LOL amount, look, a lot of projects, you're not going to get any LOL. You're simply going to have a municipal owner that's going to say, we don't have it. It's really up to you. I mean, just come up with something. I mean, there's no dollar amount that I would say, oh, if you're going to get another $1 million, then you should charge 25,000. I don't know what it is. Don't know what that amount is. It is very subjective. It's up to you who are negotiating the deal. Other questions, comments on anything that we've covered here today? This is your opportunity. Usually I rush and I get right up to the very end. I don't have any time for questions. I've left time. I only had 32 or 33 slides today instead of my typical 50 some odd slides. So I've planned on answering questions. And I think I saw one here that I didn't answer earlier. Let's see, John, you asked a question. Let's see. A lot of you are asking for slides. I see those. We'll send those to you. John Feeney, you asked a question. I can't find it in the chat room now. But maybe send it to me again. What was your question, John? Anyone else? It looks like I've still got a lot of participants here, so love to hear your comments. I'm sure that some of you have redlined and negotiated these, so anything you want to share, this is your time to do it. Any questions you have, please let me hear from you. And the recorded video is being recorded. Thank you for asking that. And we will give you a link so that you can use that video. I think it usually lasts for about 90 days or something before it disappears. So you'll be able to share that with anybody in your office or any colleagues that you would like to have watch our webinar. Okay, question. If the client wants to strike the waiver of consequential damages clause, what can we say to negotiate to keep it in? Okay, so the way I look at this waiver of consequential damages clause is very similar to the limitation liability clause. You as a design firm, you're not a risk taker. You know, I think of a contractor as a huge risk taker. They come in, they got performance bonds, they've got yellow equipment, they have huge assets in the bank, they take risks. You tell a contractor, look, I want you to put an extra 10 nails in. They never do it for free. They'll say, yeah, you got to pay me an extra couple bucks for those extra 10 nails. Design firms, on the other hand, you work by the hour. You have no real huge assets as a corporation. The client can only recover damages from you to the extent those damages are paid by your insurance. And you keep an insurance program that's reasonably priced. And that reasonable pricing is based largely on the fact that the insurance companies are expecting you to ask for these waivers of consequential damages and these limitation liability clauses. And that may be a question on your application for your insurance carrier. Do you get LOLs? Do you ask for these? Do you get a waiver of consequential damages? Do you ask for these? Do you use an AIA form? What form are you using? And so that's really built into your pricing. The reason you're able to do these at an effective price is because the client is waiving these types of claims against you. It's too huge of a risk for you to do what you're doing for your I'm going to call it a reasonable fee, take on this huge potential loss for this consequential damage. And I'll give you an example of how effective that waiver is. So in Maryland, there was a case where I won't name the company because I used to name them. They got upset with me. Their general counsel said, please quit naming us. It's a very respected engineering firm. But they were going to be an expert witness in a arbitration involving a huge, very respected, nationally known contractor. Contractor is being sued by a project owner. This engineering firm provides an engineer to testify as an expert witness as to the standard of care, showing that this contractor met the standard. Turns out during the arbitration, they find out, I guess the opposing counsel knew it, but he blew it up during arbitration, that this engineer wasn't a bona fide engineer. He didn't have his license. He was not a licensed engineer. He wasn't qualified to testify in the state of Maryland. So now what happens is the contractor loses $1 million judgment in the arbitration. So what does the contractor do? Paying the owner the $1 million, he sues this design firm saying, you had a bad engineer. This guy wasn't a bona fide engineer. That's why I lost my $1 million. And he sues. And the trial court said, yeah, that's outrageously bad. And they awarded judgment to the contractor against the engineer. The engineer then filed an appeal to the Maryland Court of Special Appeals, and that court held, no, you owe no damages whatsoever for this wrong because there was a mutual waiver of consequential damages. All those losses were a consequential economic loss. And they had probably a clause that was pretty broad, like well-defined like mine. And the court said, yep, sorry, but you are both wise companies. You both have attorneys. You know what you're doing. You waive consequentials, and that's a consequential damage. I just thought that was a great example. It's about as far wrong as you could do, and yet that clause was affirmed to say, sorry, you can't recover. Okay, so, yeah, so John, you want me to add a few more comments on the problem with living with a claim and a demand in an indemnity clause. So okay, let me just give you an example. I have one right now where I am assisting counsel in a case where it's a contractor claim against the project owner. I represent the engineer, and the owner is looking at the indemnity clause that is in the contract between the engineer and the project owner. The owner is saying, well, look, you're the engineer, you signed this indemnity clause, and you agreed to defend and indemnify me against, and it lists out fairly carefully, but it says property damage and bodily injury. Now, when I see that in an indemnity clause, I will, after the word is property damage, I say, except the work itself, other than the work itself, because I don't want to be indemnifying for damages to the actual work. It's property damage to anything else other than the work itself. That's historically the way it's written. And in this case, those words weren't there, but we're certainly arguing, well, that's certainly the intent. This engineer did not intend to indemnify this owner against damages to anything other than the work itself. That is a real problem. That's going to, it's not a clear-cut answer. That's, you would think that we wouldn't have to indemnify. I don't know if it went to court. Who knows what would happen? Hopefully, we don't have to indemnify. But that's truly living with a current demand that we indemnify a client that we actually want to work with and assist them against a contractor claim. We don't want to be at odds with our owner client. We want to work with them so that we can defend against what we believe is an incorrect contractor claim. All right, well, that's about the end. If there's anything else anyone has, I've got about 2 more minutes. Otherwise, we will say goodbye. Another minute, anyone? All right, Julia, I think we're to end here. You want to say goodbye? You want to end this program for us?